Ladies and gentlemen, thank you for standing by. Welcome to the 5 Must-Have Training Courses for 2014 webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature, which is located in the lower left corner of your screen. If you need to reach an operator at any time, please press the *0. As a reminder, this conference is being recorded Thursday, January 30th, 2014. I would now like to turn the conference over to Adam Langley. Please go ahead, sir.
Hi, I'd like to thank everyone for joining us today for 5 must-have training courses for 2014. This webinar is brought to you by Workplace Answers, and your presenter is Lynn Lieber, Esquire. Whether you're a regular in our webinars or join us for the first time, we want to welcome you, and we're very happy to have you online with us today. Before we get going, I'd like to tell you a little bit about us. Workplace Answers offers the most compelling and interactive online compliance training solution in the industry. We bring cutting-edge courseware and the latest training applications together with a dedicated professional services team to transform the way you educate your workforce. Today's presenter, Lynn Lieber, has been practicing employment law exclusively on the management side for nearly 25 years. She's conducted face-to-face employment law training sessions for hundreds of entities, and she's also testified as an expert witness in unlawful harassment matters and frequently conducts remedial training for supervisors or executives who have been accused of harassment or discrimination. A few housekeeping items before we get started. All audio should be coming through your computer speakers, so please ensure that your volume is turned up, and you may submit questions to the speaker at any time today by typing them through the chat feature located on the left of your screen. Questions will be addressed at the end of the webinar as time allows. As a reminder, today's call is being recorded. Unfortunately, we will not be able to provide the actual PowerPoint slides, but all registrants and attendees will receive an email with a link to view the archived recording and download a document with some key takeaways of this webinar. You may receive a call from one of our account executives after the webinar to ensure that you receive the link to the recording and to get your thoughts on the webinar and see if we may be able to assist you with any issues discussed in today's webinar. And we'd really appreciate if you took a few minutes to chat with them. They give you a call. And we'll be conducting a few polling questions during the presentation. So just click the radio buttons to select your answers. All answers are private, but we will be able to see the live results summary as they come in. Without further ado, I'd like to turn the call over to your presenter, Lynn Lieber. Please go ahead, Lynn.
Thank you very much, Adam, and thank you all for attending today. We have hundreds of people on the line, and many of you are very high-level HR executives, which makes me feel very good because I have huge passion for training and have seen so often in my practice how training can avoid punitive damages, huge liability, lawsuits, and I've really devoted my life to training. And in addition to what Adam has said about my legal practice, I do a lot of preventative work. And one thing I've focused on this past year is conducting neutral, objective workplace investigations. And I did about 6 of them last year, many of them where I interviewed up to 20 witnesses, wrote 50-page reports, very detailed ones. And in every one of those cases and investigations, I ask for the training records of all the witnesses that I interview. And I can tell you that even more than in my legal practice as a litigant, as a litigator, I am horrified at the lack of training that is present in the workplace. I'm currently working with a private sector employer who has over 10,000 employees, and they have a complainant, a woman who came forward with very serious complaints of sexual harassment by her supervisor, against her supervisor, in which he allegedly propositioned her in very, very graphic terms. When I went back and looked at her training records, I was horrified to see that she has not been trained in unlawful harassment since 1993. And she did not bring her complaint forward because she did not know how to, and she was scared of retaliation. Those are situations that I see all the time now. And it again highlights to me the grave consequences of failure to train and the, as we'll talk about, the return on investment of training versus facing huge liability. There really is no good reason to train, and even the employer that I referred to, they do web-based training. They just haven't, because of their large number of employees, been consistent with it. But as a defense practitioner, those training records are either going to sink me or they're going to be Exhibit A if they're in my favor. So without further ado, we're going to move on because we have a lot of material to cover to what we believe are the training essentials for 2014. First of all, our old favorite, I hope many of you, all of you do this, unlawful harassment, and we have a very important new component of that, which is retaliation, which, as you know from a trio of Supreme Court cases over the past several years, has taken front and center stage. Every case that is filed that is either a harassment case or discrimination case has a retaliation component, because under the EEOC guidelines, retaliation can be, quote, any adverse action, which could even extend to my supervisor brings everyone cookies on Cookie Wednesday and doesn't bring me one anymore since I filed a complaint. It can really be anything. And I have to tell you that employees and supervisors, especially supervisors, do not know this. They do not know how to interact with HR and be in close contact with HR when they're doing the performance evaluation, when they're doing verbal warnings, written warnings for employees who have filed complaints of harassment or discrimination. And that can really sink an organization because, as we know, the underlying cause of action of harassment or discrimination can fall out of the case, but the retaliation claim can still be active and proceed on its own with really devastating consequences. We also believe that social media is an absolute training essential for this year. As we know, it's growing by leaps and bounds, and really what you don't know that your employees are doing can hurt you very badly, and we're going to talk about some of the essentials of that. I think another very, very important aspect of training this year should be confidentiality and trade secrets. These things now, in conjunction with social media, are literally flying out your employer's door through Twitter, through Facebook, through blogging, through various forms of social media, through email. And employees simply do not know what confidential information with a capital C and capital I are for your specific organization. And finally, kind of the largest area of liability of all that most employers do not train in is wage and hour law. And we'll get to the statistics about what a huge area of liability this is and why most employers do not train on this but train on unlawful harassment, which is maybe 10% of your liability potential, whereas wage and hour can be up to 90% of your liability. So we're going to begin with our first polling question to get you involved. And Liz, would you like to kick us off on this one?
Yeah. Our first polling question asks, does your organization currently conduct training in? And just select one of these options: unlawful harassment, discrimination, wage and hour law, social media, confidentiality, trade secrets, or none.
I always find the results of these so interesting. And I will hit skip to results as soon as we get to kind of critical mass to give you all a sense of, I think it's really good for you to see what your peers are doing in terms of training in these areas. And the results are generally quite surprising. So here we go. Looking at our results, 68% of you, not surprisingly, train in unlawful harassment because that's been drilled into us. Less than half of you train in discrimination, which is a huge area that I'll discuss because we have new protected categories, we have the retaliation component, and we have supervisors that I've seen in my, especially this past year of workplace investigations, supervisors simply don't know how to deal with family leave situations, with age discrimination situations, with pregnancy situations. They just simply don't know. And sadly, only less than 17% of you are training employees and supervisors in wage and hour law. And again, this is where your major source of liability is. Again, less than 18% in social media. Again, a huge, huge source of liability. Confidentiality and trade secrets. That's great. About a quarter of you, and sadly, a quarter of you aren't doing any type of training at all. And I think what I'd like to say about that is there really is no reason when you are before a judge or jury to explain to them why you didn't conduct training, because there are so many ways to conduct training, and web-based training is so easy, so cost-effective. If you were put on the witness stand as an HR professional and you're one of those 24% that did no training, how would you respond if you were being cross-examined as to why you did not do training programs when you know from attending seminars, webinars, and being an HR professional how imperative these are? So we don't want you to be certainly in that position ever. There is an uphill battle that I know all too well in convincing the C-level why training is important. I've heard many, many C-level executives say, show me the law that says we need to conduct training. If it's not essential, we're not going to do it. There is often an impression in the higher levels of the organization that training is a good idea. It's one of those things that HR thinks we should do, but it's really not essential, that it diverts organizational time and resources. I've had many employers say that we don't want to train our employees because it's going to give them ideas, and they're going to sue us because we're now telling them about the law. Well, one thing I can tell you about Workplace Answers training is that it is very employer-friendly. For example, the unlawful harassment prevention and sexual harassment prevention courses explain to employees what is not unlawful harassment or sexual harassment as well as what is. And it describes that probably 90% of what happens that employees think is unlawful is not really unlawful. It does not rise to the very high level standards of what unlawful harassment is or sexual harassment is. And of course, senior executives, as you well know, do not need to have the training or have the time for the training. And the best part about web-based training is they have no excuses. They can do it in an airport, they can do it on their computer, they can do it at home, they can do it wherever they are. And from my experience, senior executives are some of the ones that engage in the most egregious behavior because they feel like they understand everything, they can get away with it, that in some ways the laws don't apply to them, or that they know better, or that they're running the company, so why should they have to follow that? So those are very key players in training. The current federal training requirements, and this is for employees to understand their rights under the laws, but also focusing on what they are responsible for. And one of the key things about web-based training is the policy acceptance tracking. I've had many cases where employers do in-person training, and when a lawsuit happens 2 years later, they cannot find the sign-in sheet from the person who filed the complaint or the harasser or discriminator, and they know that person was in the session. Well, maybe that person just didn't sign the sign-in sheet. Maybe they didn't acknowledge the policy while they were in the training. And how do you prove a negative years later? The great thing about web-based training is your policy acceptance, as we'll show you, is at the touch of a button for you. And you can see through Workplace Answers' very simple and easy learning management system exactly who accepted your policy on what day, and that is electronic evidence that you are going to have for years to come to use as a defense in a case. And the same thing for managers, they need to understand their role in enforcing the policies. And so many just don't have that information because they're not trained. They do the best they can, but we're dealing with complex, subtle, very sophisticated issues often, especially with retaliation. My gosh, wage and hour law. There are whole groups of employment law firms that only do employment law, that have hundreds of attorneys, that have specialized groups that only focus on wage and hour law, because these are so complex, and because we do now have many, many class actions regarding wage and hour law. And it's often very decentralized based on location. So this is a great way to do training for your managers across the board. So every manager in your organization knows about break time, about lunch time, about what is considered working time. So you're really training not just on a location-by-location basis. You're making it uniform across all your facilities. The framework for compliance training, now this is especially in the area of unlawful harassment and discrimination, comes from the EEOC guidelines to begin with, which state that the employer should provide training to all employees. And this goes back to 1999. And we also have the Farragher and Burlington Industry cases where they required employers to exercise reasonable care, which meant basically that you have policies, that the policies are up to date, that they're disseminated, and that you do training on those policies, and that your supervisors enforce them, which again requires training. And if you do that, you get a pass basically. You can say the employee did not avail themselves of our various reporting alternatives, and therefore we have a defense. And under Kolstad, all managers must be trained in Title VII principles, and this is a demonstration of an employer's good faith efforts. So moving on to another polling question, Adam, would you like to take it from here?
Yeah, the next question is, what could you show an investigator or lawyer to prove your good faith efforts for a legal workplace? Just select one of those options: paper sign-in sheets of attendees, email confirmation of enrollment, employee signature on the policy, web-based course certification, or I don't know.
Okay. Responses coming in. Again, very interesting.
All right, looks like enough have come in.
Very, very interesting again. A paper sign-in sheet of attendees, a quarter of you. Those are so easy, as I said, to be lost, or for an employee to just conveniently not sign. As HR people, we can always say, well, as you come into the room, be sure to sign the sign-in sheet. Well, what if someone doesn't do that? How can you prove that they were at that training? Maybe they got called out. Maybe they can say, well, I wasn't able to attend the beginning. I attended the end, so I had to miss it. An email confirmation of enrollment is helpful, but it doesn't show that the employee completed the course. The employee might have completed one page of the course. Again, the employee's signature on a policy, 40% of you do that. That's very good. However, again, if we're doing training, employees might not sign a policy. They can hand back in an unsigned policy. And you cannot prove, again, a negative that they attended the training and signed the policy. 30% of you can provide a web-based course certification, which is great. And I think one of the best things about Workplace Answers learning management system is it tells you as HR professionals how long the employee has spent in the course, the day they signed in, the day they completed, and the day they certified, which are all going to be key elements of your defense. So training versus not training. Training, as I said previously, meets reasonable care and good faith effort standards. It, of course, promotes a professional work environment, and it persuades investigators, attorneys, judges, and juries that you're a good employer. And really, high-quality training, as we'll discuss, is very important because it shows that you did more than just check the box. It shows that you really wanted to effectuate a change in your working environment. You didn't just want to protect yourself and your organization against liability. You really wanted your employees to learn. Not training, obviously, you're not going to have much of a defense. It's going to lead to unprofessional activities in the work environment. I believe that most of the problems that we see from a legal standpoint come from employee and supervisors' failure to follow what I call quote-unquote professional boundaries. And that's where we get into many unprofessional activities in the workplace. And this is merely because people are not trained in what professional boundaries are. And of course, it's going to lead to you being an irresponsible employer and the accompanying reputational damage. So why is training so important? Well, what I've seen is, starting at the bottom left, employees and supervisors need this information and are really desperate for it. So many supervisors just don't know. They are untrained in discipline, in termination, in layoffs. These are very complex situations, and they're often left alone. Many of them don't contact HR for help in these, and things they say or don't say can make the difference in your organization being successful or unsuccessful in a lawsuit. If a plaintiff perceives that they are treated unfairly, they can march into an attorney's office, and I can bet you that that creative plaintiff's attorney will match up what the employer did with a protected category or legal violation. Training provides increased administrative enforcement on all levels. So you can make sure that not only are your high-level supervisors, mid-level supervisors, and employees trained, you can show that the supervisors and executives knew how to enforce the policies because of the training they've received. And again, we have heightened ethical scrutiny and really vehement public opinion against employers these days that do not follow best practices. I can only imagine what a jury would think of my current case where this woman had not received training for over 10 years. And again, reputational damage in this internet age when everything about your employer becomes public instantaneously. Unlawful harassment, really our cornerstone of training, as we talked about 40, I think, % of you conduct this type of training, or 50. Again, this is very important, but this is not where your major source of liability is. The EEOC, this slide is a little confusing because the top numbers in the yellow circles are correct. The EEOC received 93,000 charges last year. They settled $372.1 million. This was the highest amount in the EEOC's history, and $6.7 million over the year 2012. And they recovered $39 million by resolving 231 lawsuits. The statistics you see in the first box on retaliation, race, and sex discrimination are from 2012, because the EEOC has not yet revealed their charge information, their detailed charge statistics from 2013. They usually do that in March. Now, I'll set the backdrop for this quickly. These numbers, this increase, almost $7 million over a year, resulted when the EEOC was going through furloughs of their entire workforce for 40 hours, where they froze their hiring, where they reduced their budgets for litigation, for for information technology, for travel, for contracts. So they were doing this amount of work and settlement with a highly reduced staff and personnel. So we're seeing, even with that, there's a great need for harassment training. And what training needs to cover is who is a protected individual. We need to update training now with GINA, the Genetic Information Non-Discrimination Act, but weight is also a protected category. Infertility is a protected category. Employees need to know what the definitions are regarding unlawful harassment, and as I said before, what is not unlawful harassment. Because a coworker being rude to you, a supervisor treating you differently than another employee, that's not necessarily unlawful harassment, although 95% of employees believe that it is. Now your training needs to cover social media, the internet, email, Twitter, Facebook, LinkedIn, and your training needs to show that complaints will be kept confidential on a need-to-know basis. Unfortunately, my complainant in my investigation did not know this. Employees and supervisors need to know that the policy covers third parties, and it needs to include no retaliation by the complaint, by the organization, by supervisors, or coworkers, and this needs to be the new expanded version of retaliation, and then again, of course, reporting procedures for bringing a complaint. So what managers need to know that they don't, and I see this again and again, is number one, what is a complaint of unlawful harassment or discrimination? Is it he leered at me, he looks at me funny? Is that something that needs to advance to HR? Or I don't like the way this person treats me? And then how to receive such a complaint. What does the supervisor say? Do they say, oh, I know, Joe's been a problem forever, and I agree with you, we need to take care of this situation? That's imputed to the organization. What to say to the employee giving the claim? Don't make guarantees. Don't say, we'll get this taken care of, you'll be transferred, we're going to punish this person, we're going to take care of this as soon as possible. They need to know what behavior can constitute retaliation, how the retaliation laws now apply, importantly, to third parties, what's going to happen next, and very critically, the employee will not be retaliated against for bringing forth a complaint, and that other employees who participate in an investigation or testify will not be retaliated against either. Here is a sample question from one of Workplace Answers Unlawful Harassment Prevention courses. I like this one because it deals with weight loss. Weight is now a protected category as a disability and also can be a medical condition. And we often think about how inappropriate it would be to make a comment about someone whose weight is higher than average. But what about someone's weight who is lower than average? Well, that could be because of a medical condition or a disability, and I'll give you some examples. It could be because the person has a hormonal imbalance, because they are suffering from HIV or AIDS. They have cancer, and they're undergoing chemotherapy that they're not willing to share with their entire workplace. So commenting on someone's weight loss, wow, that's a great diet you're going on in January. I want to be on that too. Maybe that's not why the person has lost weight. And that could be treating someone differently based on the protected category of weight. I can guarantee you that your supervisors and employees do not know this. Similarly, another protected category that you need to train in is that infertility is a disability and that employers and supervisors need to make reasonable accommodations. And this can be time off to have medical treatments. It can be a variety of things. And you also, as supervisors, need to know not to talk to the whole workforce about this. You know, where is Alana? Why isn't she here on Tuesday afternoons? This is unfair. You, as supervisors, have to protect Alana's privacy because this is a personal medical condition that you can't share with her supervisors. But you can say something about, you know, there are valid business reasons why Alana isn't here, and it's inappropriate for me. You know, I can't share those with you. So discrimination in EEO, as we said, new protected classifications, weight discrimination. Morbid obesity can qualify as a disability under the ADA. How do you make reasonable accommodations for a morbidly obese person during the hiring process? And in other concerns, in travel, maybe you buy them 2 seats on a plane. Many, many different issues there that supervisors need to know about and that employees need to know about. And gender identity is a new protected classification. This is a person's appearance, expression, behavior of their gender, regardless of their assigned sex at birth. And this pretty much throws out a lot of employers' dress codes, grooming standards, bathroom, locker room usages. So an employee can be technically a genetically female, but choose to present themselves as male and wear typically male clothing, speak in a male tone of voice. Maybe they're undergoing hormone therapy, and you need to accommodate that person and treat them the same as others, and make sure also that employees and third parties treat them the same as others. That can be very difficult in retail organizations. Like imagine a transgender person working at McDonald's. What kind of comments are they going to get about their gender identity and expression? So it's up to you as supervisors and HR people to protect against that. So many EEO topics to train on. Of course, Title VII, which covers the protected classifications, the Age Discrimination in Employment Act, the Americans with Disability Act and its amendments, which are very broad, the Pregnancy Discrimination Act, the Equal Pay Act, FMLA. I have to tell you, I see so many issues with leaves of absence. You need to teach your supervisors how to manage to prevent discrimination in the workplace and how discrimination comes up at every single term and condition and aspect of employment, whether it's a transfer, a promotion, a demotion. Anytime there is any change, discrimination can arise. And a lot of it I see a lot of age discrimination cases now. And those are the single highest jury verdicts for single plaintiffs of all. And the reason for that is because we're an aging population. Whether we're 40 years of old or older or not, that is the one protected classification we can all identify with. Because we've seen maybe how our parents, our aunts and uncles have had a difficult time getting a job or keeping a job due to their age. So juries are very sympathetic to age discrimination. I'm going to speed us along here. Retaliation, again, this is very important for supervisors to know. The Supreme Court has expanded retaliation to what is called a, quote, zone of interest. And an employee is wrongly punished for invoking their rights under Title VII. This enables a lawsuit by any third party with an interest, so not only the complainant. So this is third-party retaliation. I've done whole webinars on this, so forgive me for being brief on this. But this requires employers to carefully analyze all employment decisions, investigate all claims, not only illegal actions, because as we said, those illegal actions could fall from the case through legal procedures, but retaliation survives everything. This is a sample of one of Workplace Answers courses for supervisors on the EEO laws and discrimination preventions. This is an employee who wears religious and cultural dress and needs accommodation because of safety concerns. How do you deal with an employee like this? How do you deal if a customer or third party makes negative comments about this employee's manner of dress? This is what supervisors need to deal with today, and many employers like Abercrombie and Fitch have been slammed over lawsuits about these issues and wanting a more Caucasian workforce. Okay, Adam, take it away.
Our next survey question is, have you or a colleague had select one of these: a lawsuit, a near miss, or nothing to worry about? Just click your answer and submit. Still got a few trickling in here, and we're good.
Interesting results. I would venture to say that you or a colleague probably don't have nothing to worry about, especially after this webinar. There is a lot to worry about, and I think especially with the emerging areas of wage and hour and social media, what HR people don't know can really get them. You don't know what your frontline supervisors are necessarily doing in their pay practices. You don't know what your employees are sending out into the webosphere about your organization, about your trade secrets, about each other, posting those drunk pictures at a company party. But interestingly, 31% of you have had a lawsuit. So I think that's very telling too. That's a good third of you have been in that unfortunate situation, and similarly, almost a third of you have had a near miss. We're going to briefly go through wage and hour, which is currently your greatest employment law risk. This has really emerged in the past 10 years to be just huge. And there are so many thorny, difficult issues. It's complex because it's not only based on federal wage and hour law, which is confusing enough, but it is based on your state wage and hour law. And for example, in California, we have wage orders that employers need to follow. So some issues that come up in litigation are, under the wage and hour rubric, are: is the employee an independent contractor or employee? Supervisors need to know how to distinguish that and when to have an independent contractor under a specific contract and not make them an employee, because failure to do so can result in huge liability, tax liability. Really, that independent contractor should have been one of your employees because you exercised control over them, you directed their work. There are 20 factors to look at. California has a worker misclassification law that deals with the above, and the Department of Labor and the Wage and Hour Division also have a worker misclassification initiative. So this is a very, very big area. And it's happened more and more as our workforce has become virtual, and many employers try to save money by, rather than bringing on a part-time or full-time employee that they need to give benefits to, having independent contractors is very appealing and less expensive, but it can provide huge liability. Another huge area is proper classification of exempt or non-exempt. This is where you get hit with a lot of penalties, a lot of overtime liability by simple misclassification, and I can guarantee that your frontline supervisors do not really understand who in their workforce is exempt or non-exempt, and they do not treat them consistently within their classifications. You know, exempt, the classifications are really professional, administrative, and managerial. Those are very up for discussion, and they're very complex. California has a new Brinker case, which California employers should be aware of. I won't go into detail about that because we don't have enough time. But meal and rest periods are also very important for all employers. Are you doing that correctly? And I can tell you from doing wage and hour audits myself, about 90% of employers are not doing this correctly because, again, frontline supervisors just don't really know and understand the laws, which are changing all the time. So 80% of DOL investigations of wage and hour claims find violations, not surprising. The median verdict in discrimination-related claims, we talked about $325,000. Average cost of a harassment award is over $500,000, but I have to tell you that even greater, numerically, exponentially greater, is the cost of a wage and hour case because those are class actions. Those are huge. They can be company-wide and across every state, and they can result in not only huge liability, but think of the resources, the legal fees, and then there are attendant penalties that go with this. So what employees and supervisors need to know are the requirements per industry, per classification. They need to know how to keep time. They need to know lunch and break requirements. What are overtime issues and exemptions? A huge one is wage and hour requirements regarding travel. Very complex. Also complex, on-call time and reporting time. I would say 90% of employers mess that up in some way. What is retaliation under the wage and hour laws? And record-keeping requirements, how long do you need to keep these records? And then again, how to report potential violations or actual violations. These are two slides from the Workplace Answers Wage and Hour course for supervisors that I really like. This is one of the interactive scenarios where supervisors need to actually drag and drop these various boxes into the boxes at the right as to what is working time and non-working time. And they can't advance unless they get them right. So for example, working time can be on-call but knitting at the workplace. And non-work time can be arriving early and doing crossword puzzles. This is something, again, that employees need to know, but supervisors also need to know and administer this. Social media, what you don't know is pretty bad. Your training in this area should cover the applicability of your organization's business with regard to social media. There are some organizations that are in the social media business where employees have to tweet, send emails, blog as part of their job. There are many overlaps that employees need to know about with your other policies. And we'll talk a little bit about that in a second. But I think coverage of relevant media types, of course, is ever expanding. So you want to mention in the training the types that we have now, but leave it open to the new emerging types every day. And I think the major focus that we want to convey in social media training for employees is their reduced expectation of privacy. They do not have an expectation of privacy in LinkedIn recommendations. You should have a policy and you should train that people should just not go on and make recommendations about their coworkers. Those last forever. They shouldn't say things on Facebook about their employer within reason. They shouldn't tweet about what a terrible employer they have or about their employer's trade secrets. And then clear consequences for reporting and violation of policy. And then I think it's important, there are two different things. There's the use of social media individually, which can be at home, and employers can control to some degree what employers say about the organization through social media, even on their own time. But then there's the use of social media on behalf of the organization. And then we need employees to know what the consequences are for violation, and then have supervisors enforce these. And of course, supervisors can't enforce them unless they know what they are. So here's an example from one of Workplace Answers' courses on social media. These are employees are talking about the organization's other policies that apply to blogging. Code of conduct, unlawful harassment, internet and email related policies, confidentiality, and trade secret policies. The answer, of course, is all of the above, and employees don't often know this, that your code of conduct is implicated because maybe there's a conflict of interest in what the employee is saying over social media. With confidentiality and trade secrets, maybe an employee is working on a new, exciting, confidential project, and they're tweeting about it, or they're talking on Facebook about it to their friends about how they have to stay at work late because they're working on this new ultra cool application that your organization is going to use to blow the competition out of the water. That's a violation of your confidential information. So many employees just do not connect that, and then supervisors, again, need to know how to enforce this. So our final topic, confidentiality and trade secrets. These are flying out of your organization, not only through verbal disclosure and sometimes giving documents to new employers and things, but through the Internet. So really, to protect information as capital letter C, confidential information, capital I, you need to define to your employees what information you consider confidential information and trade secret in your organization, whether it's customer lists, customer names, pricing, whatever it is, processes, procedures, and give them specific examples so they know. They need to know what the dangers are of disclosure of this information, because these things can come about in a very simple way. This can be an employee at a trade show talking to a competitor, just chatting it up and talking about pricing information or new products that are coming out. Or a classic one that I had a case where employees were talking on a plane to each other, two salespeople, not knowing that a competitor was sitting behind them. And they were talking about confidential information about their organization. And the competitor, when they stood up to exit the plane, was right behind them, and it was clear the competitor had heard everything they said. Probably really listened closely. So employees need to know examples of confidential information disclosure, which, as we said, can often be very subtle and not something you would think about. It can be losing your iPhone, that your employer supplied iPhone, or even your personal iPhone that you use for business reasons sometimes. Leaving your computer, having your computer stolen out of a conference room perhaps where you left it. Huge examples. And obligations of the person who receives confidential information. And this is on behalf of consumers, personal identifying information, as well as on behalf of the organization. And then there are exclusions from what is kept confidential, things that are already out in the public domain. And again, they need to know consequences for policy violation and how to report actual or potential violations. And the last thing I'd like to say about this training topic is I think one key thing about training that 99% of employees don't know is that when an employee signs a confidentiality agreement with an employer, that agreement lasts forever. It lasts past the end of their employment, and they are never allowed to disclose that employer's confidential information. And many, many, many employees do not know that, and that is a source of much disclosure of confidential information, which can potentially have financially devastating effects on your business and on your employer for years to come. So a quick example from Workplace Answers. Whoops, excuse me, I jumped too quickly. Let me jump back. Here is a very common situation. This is an email that an employee accidentally forwarded to a client that contained in the lower chain confidential information about another customer. So part of this is all email etiquette. A lot of confidential information is disclosed through email. And I have made this mistake myself by pressing the send button too quickly or the reply all button too quickly. And this is something employees need to be very, very conscious of. Before they send an email, they should type the email. They should leave the to-line blank and put that in at the end. So part of this is good email etiquette and privacy etiquette. And Adam, we have, I think, one of our final polling questions.
Next question is, how does your organization currently conduct training? Select one of these. Is it in-person classroom-style training, online training, combination of online and in-person, materials developed in-house, or we don't provide training? Select one of those and click Submit.
Okay, let's skip to the results, Adam, because we're running out of time, and I think we have some interesting. So mostly do a combination of online and in-person. I think this is good. I think training supervisors in person and senior executives can be important under certain circumstances. I personally do a lot of C-level training in person because, of course, the C-level thinks that taking an online course might be below them and that they need to have some personalized education. But still, a quarter of you do in-person classroom style, which really surprises me because I've found that it's a very clunky method of training. You never can really recapture what is said in an in-person classroom style training. It can get out of hand. People can air their grievances. People can set you up, as I've had happen. And again, there's no real guarantee that you can show that person has been through the training because they might not sign the sign-in sheet or the policy. Okay, quickly moving on. There's more administrative oversight than ever. The DOL, EEO, and the OFCCP are all state agencies enforcing employment laws due to reduced budgets. Now they all work together. So training is no longer just a good idea or an affirmative defense or a preventive strategy. It is really a requirement, and there are direct penalties for not training. If you are investigated and haven't been training, you will be fined. So let's look at some best practices. Using training dollars carefully. Training is more closely scrutinized than ever. A jury will see your entire training program. And you better be able to make sure that you captured exactly what those employees were trained in. Training needs to be up to date. 5-year-old training in unlawful harassment is not up to date. That does not meet the standards of exercising reasonable care. It needs to be something that can easily be deployed to the entire workforce and reduce liability. As I've said, poor training, in-person training, can actually increase liability. So jumping ahead, outsourcing is a lot safer and smarter, we feel, because you can have legal confidence in a high-quality third-party vendor like Workplace Answers. There's interactivity. It's consistent across the organization. The courses are 100% attorney tested and approved. They are in keeping with the evolution of the law. They can be specialized. They're more effective because I think not only are they cheaper, but I think employees take the one-on-one experience more seriously. They're part of an affirmative defense. They are trackable, so it's going to track completion, and insurance is not a prevention strategy, so we really need proper prevention. So here's just a quick breakdown for those C-level people who want to say, what's the ROI? Well, typically most employers train in unlawful harassment. That might mitigate your risk by about 4%. Ideally, if you're going through this whole suite of our courses that we're describing today, you can reduce your cost as a mitigated risk to 1.2%. That is a very small price to pay for a huge amount of liability. I'm not going to go over this. This is more something that you can talk to a Workplace Answers salesperson about. This is the Workplace Answers very full course catalog. It's very comprehensive. These are all legally approved and created by attorneys. They're all interactive, and they are all highly engaging and thorough. And the Slate Learning Management System, I like to say it's elegant in its simplicity, which is very unusual for a learning management system. This is a screenshot. This shows you the percent completed, the time employees spent, the day they accepted the policy, and the day they completed it. This is available at the touch of a finger. And you can also get on-demand reporting to see at just a snapshot of how much of your training initiative has been completed by your employees. So with that, we have a last polling question for Adam.
So our last question is, what's your interest level in training like this? You have no interest, just like the information here. You are interested, but not at this moment. And the last option is if you would like to have a 30-minute training consultation, select that option. If you would like to have someone contact you right away about our products, please click that button, that 30-minute training button. But if you're not interested in being contacted, do not click that button.
Okay, let's get on to some questions. I'm anxious to hear what the participants are interested in.
All right, our first question is weight a protected category everywhere? I know it is in California. Is it everywhere?
It is in California, but it is now under federal law as a disability. Morbid obesity is considered a disability and can be a medical condition within certain parameters.
Okay. All right. We have another question here. Can you discuss social media, especially Facebook? I've heard lately many employees are winning lawsuits stating that it goes against their freedom of speech.
Yes, there is an issue with the National Labor Relations Board, who typically administers unionized employers. They have now gotten into the private sector, and they are controlling what employees can say and cannot say on social media. For example, if it all deals with Section 7 rights to engage in protected and concerted activity. So you might not be able to discipline an employee who is blogging with another employee or talking on Facebook about a term or condition of employment. But there are many other areas you can control, and there are ways to write policies to give employees their Section 7 rights, yet protect your trade secrets and protect your reputation. But that again is a source, that's an hour-long webinar in and of itself. And the law, that law is constantly evolving.
Okay, and one more question. For sexual harassment training, one person asks, I was told that it's not mandatory to give to employees and that it's only for the supervisors. Is this true? If we have to give to employees, what is the mandatory hour for them?
The mandatory hour?
I guess time limit?
Yeah, I mean, I recommend, and I mean the EEOC guidelines say that we are supposed to train all employees. And if you're sued, guess what plaintiff's counsel is going to come up with? Why didn't you train all employees? You don't want to be in my situation where an employee is sexually harassed by her supervisor and hasn't been trained for 11 years. So it goes to punitive damages. I recommend training once a year. I think the key components, I think, are having those up-to-date protected classifications, describing what is and is not unlawful harassment. And I prefer not only sexual harassment, but unlawful harassment, which covers all the protected categories. So making jokes about someone's age could be harassment. Making jokes about someone's ethnicity or the way they wear their hair based on certain cultural norms. So it's really broader than that. But I do think about 1 hour per year per employee is what is the legal norm and required at this point. And I think employers that don't do that are opening themselves to huge liability.
Awesome. Thanks so much, Lynn, for an awesome presentation. And thanks, everyone, for joining us today. Please visit workplaceanswers.com for more information on HR compliance training, as well as many other types of training in your workplace. This concludes the presentation.